Hi, everyone. Thank you for being patient. We're going to get started in just a moment while I see some of the attendee numbers click up. Thank you all for joining. We'll just get started in just a minute. Okay, I think we can get started. Thank you all for joining us on this beautiful Friday morning. Appreciate your taking the time. This is a roundtable discussion on the South Carolina redistricting case that was argued before the Supreme Court this week. My name is Brett Edkins. I'm the Managing Director for Policy and Political Affairs at Stand Up America. We are a progressive advocacy community of nearly 2 million people nationwide, and we're also proud members of the Just Majority Coalition. Today, we're joined by other members of that coalition, April England Albright, Legal Director and Chief of Staff at Black Voters Matter, Michael Huggins, Deputy Senior Director of Policy and Government at Color of Change, Lindsay Langholz, Senior Director of Policy and Program at the American Constitution Society, Reverend Nelson Rivers III, VP of Religious and External Affairs at the National Action Network, and Portia White, Vice President of Strategic Partnerships at End Citizens United, Let America Vote. Thank you all for joining us. Today, we are going to talk about redistricting, the Supreme Court's case law on redistricting, the case that was argued this week, its implications, and why our groups are supporting Supreme Court reform. We have a lot to discuss, a lot to unpack, so let's just dive right in. On Wednesday, as most of you know, the Supreme Court heard arguments in Alexander versus South Carolina State Conference of the NAACP, which challenged the constitutionality of one of the districts in South Carolina's congressional map. To start, I want to turn this over to April. April, could you help us take a step back and talk about the history of redistricting litigation, the rules of partisan versus racial gerrymandering, and perhaps explain the distinction between racial and partisan gerrymandering, where the law stands on that right now?
Yeah, I'll try to be brief. I think people talk about, they think about the court and they think of it being this place of, where legal scholars go and just the best legal argument grounded in legal precedent prevails, and that you have, judges who are sitting there, who are blindly looking at records and making decisions on constitutionality. But we know that that's not always the case, right? That we do have judges who are, a part of political movement, and no place is that more prevalent than looking at the voting rights cases and its history in this country, right? And so I think it's important, we look at the cases that we're seeing now. We all held our breath as the court looked at the Milligan decision to see whether or not they were going to just put to death Section 2 of the Voting Rights Act. And why that was important, of course, is because in 2013, the court decided that Section 4's, test that was, entered when the Voting Rights Act was initially, instituted, was no longer constitutional, thus putting to bed Section 5's preclearance protection that kept us from having to file these cases, or so many of these cases, under Section 2. So here we are now, the court, since 2018, actually, looking at Section 2 with a different lens, because there's a different court. And so now we're looking at, you talk about partisan gerrymandering, which is the idea that one political party over the other can draw maps in a way that favors one political party over another political party. And we saw the court in 2019 saying that, the federal court had no more jurisdiction over partisan gerrymandering. And so you can no longer bring those cases, even if you have a state like North Carolina, which was the case that was before the court in 2019, that clearly favored one political party. Well, the Supreme Court will no longer deal with that. Certainly, there are state constitutions that provide greater protection around or against political gerrymandering, but that's not all the states, right? We know of a few, but not all the states give that greater protection. So right now, you have a situation where in states, they can draw lines that favor a political party over another, and it will go unchecked by the federal system and SCOTUS. And so now we're just left, right, cleaving to Section 2 of the Voting Rights Act to look at any type of, racial preferences or wrong drawing of maps. And so we see the court after Section 5, right, being minimized in its protection. Now Section 2 is under that same gun. And we were excited that the court used the traditional analysis and protected the ruling of the lower court in the Alabama Milligan decision. But now we find ourselves in this most recent case, it appears that the court is now looking at, and I think somebody else will discuss that, greater, that the court is now revisiting whether or not the clear erroneous standard, can be minimized in a way that allows for the appellate court to go back and check, right, the credibility of the factual record below. So they're trying to come at it a different way. And that is what we've seen, right? In 1980, when the Section 2 was first enacted, we were left under the guns of having to prove intentional discrimination. And that was very, very difficult. But in 1982, right, the Congress got together, issued an amendment, and created a totality of the circumstance test, which we are now referring to the Gringles analysis. And what that did was take from 1980, where there were only 3 Section 2 cases, immediately 5 years later, you had 178 cases that were then filing under this new amendment because it allowed for a different kind of record, right, to be presented in order to prove that Section 2 was violated. And so the court, since 2018, under a case in Texas, in Arizona, has started to revisit whether or not that analysis or those applications of those principles can still stand up next to the 14th Amendment's requirement that race not be considered. And so that is kind of a quick, and the last thing I will say really quickly to open it back up is we have to understand that that the court right now, Chief Justice Roberts, since he was a clerk with the Department of Justice, since he was an attorney, with under the Reagan administration, was very clearly trying to undermine the protections of the Voting Rights Act. And so when you understand that, and when you understand that he has never felt that the Voting Rights Act or that the state should be involved in providing greater protections for minority citizens and marginalized citizens in this country, then you understand the direction the court is taking in its analysis of the Voting Rights Act. And you understand why attorneys who fight these cases, with each of these cases, are holding and fighting to what appears to be a protection that will probably not survive within the next 2 years under SCOTUS. And so you got to understand the history of the development of litigation to where we are now, but you also got to understand the people who are now on the court so that you can understand why it is important to talk about, changes to the Supreme Court, that you are fighting for. You understand that this court is not just blind jurists making decisions on constitutionality, but they are actually, in many regards, a political arm of one of the political parties in this country, and are, hell-bent on using the courts and jurisprudence to change that philosophy, not because it's constitutional or not, but because it is what they desire the Constitution and the law to do in this country. And so that's what I'll say. I want to open it up because I'm sure a lot of people have a lot to say about this topic, but those are the state of affairs that we're in as it relates to Section 2's history of litigation in the past and where we are now.
That's incredibly helpful background, April. Thank you so much. And unfortunately, you're giving me flashbacks to law school and all the books I had to read back then, but incredibly helpful overview. You mentioned the Allen versus Milligan case. And Lindsay, I was hoping, last term in Allen versus Milligan, the court ruled in favor of Black voters who challenged Alabama's congressional map. Can you talk about how that case is different from the case that was heard just on Wednesday?
Sure. There's a couple different ways that that's different, and April did such a great job teeing it up. I won't go too much into the details of Allen versus Milligan, but a couple of things to highlight. One, the Supreme Court actually let Alabama's map be in place for the 2022 election. A lower court found that the map racially gerrymandered and illegally diluted the votes of Black voters in Alabama. And yet the Supreme Court took to their shadow docket a way in which they dispense of decisions without having to hear full briefings to say, actually, we're going to put that on hold. We're going to take this case up and we're going to hear it later. And so they let that map be in effect for the midterm elections in 2022. If you fast forward, the court, as April mentioned, somewhat surprising to some of us, did the right thing and upheld that Gingell's test, applied it very matter-of-factly, and said, we're going to keep the law the way it's been, and struck down the map. I think that it's really important to highlight that they let that map be in place for an election while they kind of sorted it out amongst themselves. But let's take it from last year on and say, hooray, they actually did strike down the map. They went back to Alabama and said, you have to redraw this. You have to create a second opportunity district, or a district where Black voters have a meaningful opportunity to elect a candidate of their choice. And they did that because they said it violated Section 2. The Gingell's test is kind of under one track. The claims there were brought under Section 2 of the Voting Rights Act. Here in the Alexander case, we're seeing challenges based on the 14th and 15th Amendment. And so it's actually a related but somewhat different test. If you listen to oral argument, you heard a lot of conversation about Cooper, which is a 2017 case. And the court is now trying to figure out basically how to deal with a legislature that comes forward and says, we were just partisan gerrymandering, it's fine. This other type of gerrymandering that you've said isn't justiciable, we're going to take to mean is totally fine. And we're going to claim it as our defense. And say, this is what's going on. We're not racially gerrymandering, even though there's an extensive factual record in this particular case in Alexander that talks about intent and looks at the ways in which Black voters were moved out of this particular district, District 1 in South Carolina, to maintain a percentage. And I know other people are going to get into it. I'm not trying to get into the details there, but there's just different facts at play in each case. Redistricting cases are very fact intensive. And so we can look at trends and look at Allen versus Milligan to have a little hope, I think, but also they're very different cases. And so we're going to have to kind of take it on its own.
Thanks, Lindsay. Let's dive into the actual case that was argued on Wednesday a little bit. Alexander versus South Carolina NAACP. Michael, can you tell us about this case, the claims that were brought against the South Carolina legislature?
Of course. So I think everyone's been talking a little bit about the facts so far. I'll keep it very brief because I'm sure everyone will certainly have their thoughts. But yes, this particular case, the Supreme Court heard oral arguments in Alexander v. South Carolina State Conference of the NAACP, challenging the constitutionality of one of the districts in South Carolina's congressional redistricting map. The map in question, or the map in dispute, was actually adopted in 2021. The new map nearly moved 2/3 of the Black voters in Charleston County out of District 1, which is currently represented by Republican Nancy Mace, into District 6, which is represented by Democrat Jim Clyburn. They also moved Republican areas in nearby counties into District 1 from District 6. So as Lindsay already said, the state sort of already defended the plan against allegations saying, well, this isn't racial gerrymandering. We're simply trying to create a safe seat for Republicans. This is partisan gerrymandering, nothing to see here. Of course, they already hold a 6-1 advantage in the state's congressional delegation, which is, sort of, putting salt on the wound for, Black people in South Carolina who are not dumb and who can see what is clearly going on. And so the NAACP is arguing that obviously the South Carolina legislature intentionally divided the Black population of Charleston County to dilute the vote. I mean, moving nearly 2/3 of Black voters is ridiculous. And it's clear what the state legislature was trying to do. So now the court is poised to decide whether state lawmakers can actually use race to identify Democratic voters and then use the data to draw district lines intended to diminish Democrats' ability to elect a candidate of their choice. So I think the implications are really, really dire. I know the other folks will get into sort of the implications from the oral arguments and what was heard. But I think in this case, the facts are so lopsided that I think it's a pretty heart-wrenching case.
Thanks for that background, Michael. Let's talk about the oral arguments. The mainstream consensus seems to be, after Wednesday's oral argument, that the conservative supermajority on the court will uphold South Carolina's legislature's power to racially gerrymander under a guise of partisanship. Let's open it up to anybody on the panel who would like to. What are the tea leaves that you're reading after oral arguments? What's your reaction? What do y'all think after the oral arguments this Wednesday? Lindsay, I know you had thoughts, and then others could. Oh, I'm sorry, Reverend Rivers.
Well, I was not in the court, but we had folk in the court. By way of stepping back a little bit by my background, I was the executive director of the South Carolina State Conference of NAACP from 1984 to 1994, and I started my work on the ground as a local branch president, but I've been working in reapportionment against South Carolina from 1978 until I got back home as a pastor. I'm now the Vice President of Religious Affairs for National Action Network, of course, but South Carolina has a long history. April did a tremendous job, such a good job. I think that if a state, there are many times when that can be used, because when we get into this now, folk really don't understand the history of how we got here. And if you don't understand the history of how we got here, you can think that all this is just these folk going nuts and this is a brand new thing. No, in South Carolina, this is who we are. This has been going on a long, long time. We were the first state to challenge the Voting Rights Act. We were the first state to challenge the Motor Voter Act. This is us, unfortunately. The difference in this one is, frankly, we didn't think the lower court would do what it did. That was pretty striking that they did. We knew that when this happened, we believed it was already baked, that we believed this was an inside deal from the get-go. The Republicans controlled how the lawsuit was filed, what the facts were, not the facts so much, but how they would be viewed. So to be in front of the Supreme Court on this is pretty significant, no matter how it goes. But I'm not encouraged, but I'm more encouraged in what you said, Michael, about the folk who went to court. Now, that they were not all lawyers. Ironically, the individual plaintiff in this case is the president of the National Action Network chapter on Hilton Head Island in South Carolina, because it's in Nancy Mace's district. The significance legally is that it codifies what South Carolina has been doing for a long time. The reason our General Assembly changed from a Democratic General Assembly to a Republican is because of political gerrymandering, which in South Carolina is racial gerrymandering, because we flipped. South Carolina used to be an all-Democratic state. You can pay somebody to be a Republican. In fact, if you rode around my town of Charleston, I'm from Charleston. My church is in Charleston County. I live in North Charleston. This used to have a license plate that said Land of Lincoln. And if you were riding around in Charleston with the Land of Lincoln, they damage your car and try to shoot you. That's how much they hated Republicans when I was young. They flipped the script. Now they hate Democrats, because whatever black folk are, that's what they hate. I'm being transparent. Whatever black folk are in South Carolina, that's what they hate. So one solution, I say tongue in cheek, if we become Republicans, they're really gonna be messed up, because they won't know what to do. But this case was really about codifying that you can use you can use racism and cover it with politics or partisanship, because in South Carolina, party is race and racism. There's no way to look at it. When the Republicans say, we didn't mean to do it against black folk, we're just trying to get an advantage, I'd be doggone, yes, you did. And we need to call that out. How we call it out is different from how we went in court. Charleston, if you know what they did, they literally cherry-picked the black folk and put them in Jim Clyburn's district, because Nancy Mace was going to have a very tough race the next time. Because she won, she's on the wrong side of Trump. She's trying to do her best to get on the right side, but she was on the wrong side of Trump. He endorsed the last two folk who ran against her. And Joe Cunningham could have beaten her the first time, but he didn't. So to make sure that Nancy Mace, because really they don't like her, this is not about her. This is about making sure whoever they succeeds her has a safe seat. This is always about the safe seat. So we should not be discouraged. And don't think people in South Carolina sit around waiting, especially in Charleston, that y'all coming to save us because these crazy white folk done it again. No, we believe the court is going to do what the court has done for years and years and years. I started this work on the Mobile versus Bolden. I started this work literally when the court we had to get intent proven. Then we had to say they didn't mean to do it, y'all. That's how long this has been going on. Every iteration of the court has come differently. The consistent person, y'all have not named, the consistent party in this is Clarence Thomas. Clarence Thomas, even more than Roberts, Clarence Thomas, when he was being confirmed, gave that mile speech, I call it, when he went black for about 5 minutes when he was in front of the court and said, y'all trying to lynch me. The truth is that Clarence Thomas in the Etowah case, Gaston, Alabama, that's when they started going after the basics of Section 2 and targeting Section 5. That is still continuing. What we have to understand is that this is really more about the election in 24 than it is about the legal action of the court, because getting folk on the court is the only way, and trying to pass the John Lewis voting rights bill are the really only ways. So however this plays out for us strategically, we are not, in fact, we are shocked that they even taken this up. We believe when they did it, we have to fight them a different way. So the prayer has been answered at the fact that the court is even dealing with it. And I think that's why the novice who went to the court really thought, that so sounded good. Ketanji was off the chain. Kagan was on the money. And even Clarence Thomas seemed to be interested. I have no delusions about that. I believe they're going to do what they've been doing, and we need to be prepared for how to act. We don't think that they're going to stop the Republicans from being racist, because they have too many protections at the court level. But we are prepared to act, because we have always had to act in South Carolina against a racist General Assembly, and they didn't change last night.
Thank you so much, Reverend Rivers. Anyone else want to chime in with reactions from Wednesday's arguments?
That was so well said. I'll only add on to say that Justice Jackson was incredible during oral argument, and you could really hear her in real time bring forth the issue that was happening of, what are we doing here? You know, we're supposed to be reviewing for a very specific legal standard. If there was an error that the lower court had decided, there are very specific rules in which the court is supposed to go about that. And it felt like the conservatives on the court threw that out the window and were like, let's start over. We want to get into it. We want to look at all these reports that experts filed and really dig into the nitty-gritty, which is beyond the court's traditional role. And so Justice Jackson, I thought, did an incredible job just on both parties, time and again, being like, what are we supposed to be doing here? Because it seems like we're just rewriting the rules in real time. And so I think that we're gonna see what the result is at the end of this. I think that Alan has given us all a little bit of hope that maybe our predictions won't pan out, and that the court will decide to stand on the side of Black voters in South Carolina. But I think that there's real reason to be pessimistic, and you could certainly see certain justices on the conservative side seeking the answer that they would like, and finding a way to kind of back in themselves into it.
And give a chance, April, Portia, Michael, any other comments from the arguments?
I think everyone said everything well.
A little hope of optimism, but healthy
I have
dose
no
of-
optimism,
Okay.
but I'm always cynical about the Supreme Court. I'm just going to be real. I think the reason why we got the Milligan decision was because they knew they were going to blow up affirmative action. I think if they weren't going to blow up affirmative action, we probably would not have gotten a favorable decision. You know, I think people should look back at the decision that Lindsay talked about, right? Where it seemed like when they went to the shadow docket, it seemed like Roberts signed on with the liberal justices. But if you read his even small paragraph, he felt the use of Purcell was ridiculous, but he did talk about it might come a time when we need to analyze and look at whether or not, these factors are being correctly applied, but this is just not the way to do it. So I'm very pessimistic. Reverend, I everything you said, ditto. I think we're about to enter an era of the Mobile versus Bolden case that you alluded to and were a part of. And I think that there's probably other places to talk about what's next, but I'm just not very optimistic about the courts. And I think the reason why they're trying to re-examine now, right, the clearly erroneous standard is because they want to have an opportunity to go back, undo what the lower court did, and actually make this be an issue of partisan, because they've already decided that the Supreme Court is not going to evaluate, and it gives them a way out, and in a way that doesn't look like they're contradicting themselves as it relates to the Section 2 traditional cases.
Well, one quick point about this is when you're Black in South Carolina, Black in America, Black in South Carolina used to be paranoid because you believe they're coming to get you, and it's true. But there's an issue at the heart of this, the separation of powers of the quote unquote branches of government. The Supreme Court, on its voting cases for the last several decades, have basically said, we don't care what the legislature or the Congress has said. We plan to come get what we want. The real issue for me is, how do we prepare for this onslaught and strategically work a way around giving them this opportunity over and over again? Because what is clearly going on to me from when we started this in 1978, that this is really about the Supreme Court being both branches of government. And they're worried about how the electorate is going to change the demographic of who votes for who, so that the Congress is going to, in my lifetime, I pray, will go back and reestablish Section 2 and 5 legislatively. And what the court plans to do is to stop that. And they know that since you have lifetime appointments, they will be here longer than these 4 or 6 years that these folk are elected. That seems really conspiracy, but I believe in conspiracy, especially being Black and living in South Carolina. My whole life has been affected by one long racist conspiracy of white supremacy, and it's manifested in many ways. But an issue is, do we really have 3 branches of government, which is why the composition of the Supreme Court and being unlimited in what they can do and how long they can serve is a danger, I believe, to this theory that we have called democracy.
If the court will issue its ruling, likely next spring, Reverend Rivers and then April and anyone else, I'd like to ask you a little bit more about the impact the decision you think will have for South Carolina and more broadly for future challenges to racial gerrymandering across the country.
For me, it's because our General Assembly is already doing this on steroids. They're really bad because they have a supermajority. So for us, if the court sides with us, it would be like, really? Okay, we can do this now. What I think is more reasonable, at least for us, is they're going to side with the Republican, white-dominated state legislature, because those are their boys and girls. We had 5 women to stand up against the abortion case in South Carolina. 3 of them were white female Republicans. We're pretty sure all 3 of them will be gone soon in the election because of the racial gerrymander that this is. So in our case, if the court sides with us, then we get those people back. We then have a chance to change if not the party that runs that district, at least how they act, because they know they can be taken out. If they rule against us, then we already expect to do what we have to do because we're doing it now anyway. We are not waiting on the court to ride in and say, we're going to save y'all, because that's not what the court has done in the last several years. I'm working with the folk in Alabama. They still can't get over it. They're still sitting around talking about what in the world happened over here. So we're working to help them, but they really are walking around in shock like, who, somebody doped Clarence that day? What happened? Did y'all steal his body? I don't know what. But anyway, the Alabama folk are still stunned. We don't have any false hopes. We don't believe they're going to go with us. We're prepared for them not to do it, and we're going to do our work anyway.
Thank you.
You know, in our organization, you know, we certainly believe in a strategy that includes litigation, which is why we engage in litigation to challenge some of the existing racial gerrymandering cases, as well as some of the more voter suppression tactics. But we are fundamentally aware that change in this country, including in the court, happens, you know, in the community first. We are very clear that we wouldn't have gotten those favorable decisions, you know, if in fact the community wasn't organizing around voting rights. We always say that the Voting Rights Act was not voted on. It was people organized to get the Voting Rights Act, right? And with that said, this is the era that we're in. We have absolutely lived in America where, like in the Mobile versus Bolden case, and I'll bring that up again, where despite the presence of and the percentage of Black voters, there were no Black representatives. And the court did not care.
Absolutely.
And so we know, just like in the Dred Scott decision, and I always bring this up in most of the forums that we talk about this case, was that in stroke of a pen, even though slavery was not in each state, just by deciding in that case, that pivotal case, that, you know, Black men had no rights that a white man was bound to respect, it took slavery and nationalized it, even took it outside of the states that were deemed. That is how pivotal the decisions of this court is, and how pivotal the decision of this South Carolina case is, because what it does, it gives a blueprint to show other states how you engage in a way to get around the protections allowed in the law. And so what I believe is, if they decide, the implications for us, if they decide to allow South Carolina to do what it's done, then that is what's going to happen. You're going to see a national movement, just like after the Shelby decision, you begin to see a plethora, tsunami of laws that got enacted that began to restrict access to the ballot. The same thing will happen with this South Carolina case. And the last thing I will say is that the Voting Rights Act is great. It does provide some protections when enforced. But as Reverend talked about, right, we see this collapsing of the GOP, of the Supreme Court of this country being another arm of the GOP.
That's right.
So what are we going to do about it? What type of permanent changes must we begin to fight for? The idea of revising the court, right? Because there's no constitutional limit to the number of justices that are on the court. We have to really fight for that. That is a structural change that needs to happen. There are other structural changes that people don't like to talk about in America, like proportional representation. And I want to remind people that in 1982, when they were talking about this amendment that Dole produced, the reason why they talked about it was they did not want the discussion of proportional representation, which is this idea that people are guaranteed political representation in this country. And so we've got to start exploring, like our dear sister Lonnie Guinier used to talk about, whether or not that is something that we've got to begin to enshrine as a structural change in this country, so that we don't have to live at the whims of whether or not a court is going to determine that marginalized folks have rights or not. And so I think that those are the kind of implications that I think in spaces like this, which is, I'm excited to be in partnership, talking about changes to the court, but we've got to go a little bit beyond that and start really exploring what other political changes can we put in place to protect the rights of marginalized people, political representation in America. So that is, you know, what my contribution will be in extension to Reverend Rivers' statements.
Thank you. Thank you. You're all talking about this long history of the court in attacking and weakening the right to vote, institutions of our democracy, targeting marginalized communities from Shelby County to Bernovich, Citizens United, Moore v. Harper. In recent years, these are just the recent years. Portia and then Lindsay, maybe can you talk a little bit about these cases, this pattern of anti-democracy rulings from the court?
Yeah, absolutely. I mean, so many of my fellow panelists have talked about this, but what we've been seeing for almost a decade at this point is that the court has been systematically chipping away at the Voting Rights Act, right? They've been going after Section 4, Section 2, Section 5. Shelby v. Holder attacked Section 4, saying that Republicans can just pass now all of these anti-voter laws that restrict people's access to the ballot box. And what they keep doing is chipping away and trying to see how much they can get away with and how much more they can get away with until they've completely eroded the VRA, right? In Section 2, we talked about how the right to vote can't be denied based on race, right? But it can be, as we've seen now, be restricted based on your whether or not they think that you're a Republican or a Democrat, because that's what we're seeing, what led to the case on Wednesday. We've been seeing in the last 3 years, actually, over 100 laws that have been passed in 33 states. That's just since the 2020 election. So clearly we are seeing how states are taking these Supreme Court decisions and are taking it to the max, right? Like they are systematically targeting voters being able to have their voices heard at the ballot box. But what we're seeing is that it's not just about taking away our voting protections. The Citizens United decision opened the door and allowed dark money to run amok, basically, in our politics. So it allows these special interest groups to buy these corrupt election officials, which then get to buy these Supreme Court justices and get to buy these judges and get to buy these officials who get to take away power from the voters and put it in the hands of these special interest groups, these very wealthy special interest groups. This corruption means that these extreme agendas that we're seeing in the courts, it's clearly not the will of the voters, it's the will of the wealthy. And they're able to pass through the court and become laws and then succeed at the Supreme Court because it's all been a pay-for-play system. We saw with the independent state legislature theory, the Moore v. Harper case last term, that the court is directly targeting democracy, right? Like, first, we don't actually understand why they would take up this case, but even though they said that the state legislature theory is crazy, what they did do is leave the door open for future intervention by the federal courts to undo the protections that the state courts might enforce. So what I think, honestly, is until we're able to root out the corruption in the Supreme Court hallways that we're seeing in the headlines every day, that they will continually, systematically attack the core aspects of our democracy, not just the right to vote, but all aspects of our democracy.
One thing I want to just pull out of what Portia just laid out so well is the court has really sought opportunities to expand its own power while doing this. And so, as she mentioned in the Moore versus Harper decision, yes, they rejected the maximalist version of the independent state legislature theory, but they expanded their power and even didn't define it. They just said, we're putting ourselves in the game here and we're going to, for ourselves, create this opportunity to overrule a state Supreme Court interpreting their own laws. And you see it time and time again through a number of things. One, April referenced it earlier, but they've created out of whole cloth what they call the Purcell principle, which is this idea that if something is too close to an election, then they're going to let the state rules stay in place because they don't want to interrupt it. But they're not applying that in any coherent fashion. They basically use Purcell whenever it gives them the result that they want. And so what you're seeing is, in the case of Allen versus Milligan, the Alabama case, they let that gerrymandered map be in effect. But then in other places, they're changing the rules 3 days before an election to say voters can't vote this particular method because we don't like it. And you're seeing them time and time again create rules for themselves. They're creating roles for themselves. As we saw in oral argument this week, they're deciding when they want to apply the clearly erroneous standard or not. And they're also changing the history. And so I think, we've talked about Rucho a couple different times. I was listening to oral argument and Justice Gorsuch was like, we all agree the partisan gerrymandering is fine. What we're trying to figure out is this, that, and the other. And it's like, Rucho was a 5-4 decision that was bitterly fought and was horrible. It's unleashed a lot of confusion and chaos, and they're treating it as if everyone agrees to this. And so they just keep moving this window against the voter. That's really the only coherent strategy, is we're expanding our own role, and it is at the expense of voters trying to vindicate their rights.
Thanks, Lindsay. In a moment, I want to switch to court reform and hear from all of you. One last question before we do. Michael, how do you think this case relates to other cases the court's been hearing about race, where race is at the center of the constitutional question at hand, like the recent affirmative action decision or other cases?
So as everyone has described, this particular Supreme Court is clearly anti-fair representation. It's very clear. Now, at first glance, one might say that, oh, affirmative action, gerrymandering, they're two distinct issues, but they're both actually very much related. It's related to the struggle for fair and equitable representation in American society. Affirmative action was designed to address historical inequalities by promoting diversity and inclusion in educational opportunities. It was never about excluding white applicants from opportunities. On the other side, conversely, gerrymandering was trying to, the attempts to address gerrymandering through the Voting Rights Act was also designed to address political representation in society. Gerrymandering is undermining fair representation by manipulating our electoral districts to favor one political party over another. So I think the implication is very clear. The Supreme Court in this particular bench, it is very hostile towards investment. It is very supportive of investments in privilege and exclusion, and very hostile to Black lives, Black futures, Black students. And the implication is clear. What, I think a lot of people have talked about, what are the implications for things like the Civil Rights Act, of Title VI. I think Reverend Rivers actually said it very well. I think this is part of a larger conspiracy. And actually, Avery, you said this very well too. This is part of a larger conspiracy to chip away, not just at our rights as it relates to political representation, but our rights broadly, protecting, a number of non-discrimination protections that exist in law. And so I think this, I think this is this should be a huge red flag. This should be a warning to everyone. We have to make sure that this Supreme Court is accountable, for the role that they're playing in exacerbating inequality. So, I'm somewhat I'm pessimistic about the court. I'm always optimistic about life, but I think this is, I think there's real potential danger to a lot of critical non-discrimination protections across our entire government.
Thanks, Michael. Let's talk about court reform. The Just Majority Coalition, of which we're all a part, believes Congress should add 4 seats to the Supreme Court to restore balance. Other reform options are out there. Portia, maybe I can start with you. Michael, Reverend Rivers, everyone else would love to hear from you. Can you discuss why reforms like this are needed, and maybe why your organization is now out there supporting reform?
I mean, I think we've just spent the last 45 minutes telling y'all that there has to be a change at the court. We are seeing, listen, I won't necessarily say I'm always a conspiracy theorist, but as a Black woman who grew up in Mississippi, who now lives in Georgia, I have to know that the system is being designed against me and is being reformed to consistently oppress me. So I don't even think that's a conspiracy. I think that that is a fact that I can have living proof of. So we're seeing a court that, again, has been bought and paid for, right? That keeps expanding their power. Like Lindsay said, we are seeing every single term, every case, there are cases that are coming out that are designed to oppress more and more people. And then we're seeing all these cases of the court being plagued by scandals, right? Like I said, every other day, we're seeing a new story about how somebody got a yacht trip, or somebody's tuition, somebody's grandkids' tuitions get paid, or something else is happening, but they're not disclosing it, and the person has business in front of the court, right? So that means that we have a problem. That means that we have something is wrong. Something is wrong in the water where we need to fix it. I think that right now, I know that right now the faith in the Supreme Court is at an all-time low. And by all-time low, let me give y'all numbers. The latest poll says that 25% of Americans have faith in the Supreme Court. That means that 75% do not. The majority of Americans realize that there is a problem at the court. I can also tell you that most Americans, I mean, the vast majority of Americans support court reform. Again, numbers here. The poll showed that 67% of voters believe that a code of ethics and a method for investigating violations would help to restore trust in the institution. 64% of voters believe that the Supreme Court makes decisions based on the influence of special interests and their own political ideology versus a fair and impartial representation of the law. Even worse, 80% of voters believe that the Supreme Court should require organizations that spend money to influence judicial decisions, they need to disclose their largest donors. And 74% of voters feel that strong repercussions to Justice Clarence Thomas ethical violations, 74% of voters feel that there should be strong repercussions for Justice Clarence Thomas's ethical violations and that he should face some sort of penalty. So time and time again, we are seeing that voters recognize that there is a problem at the Supreme Court. This is all backed up by facts and numbers. And I think the Supreme Court is going to have to start implementing some sort of ethical code, right? So we've talked earlier about how the Supreme Court can kind of make some changes, right? So we can expand the number of justices on the court. This is not constitutionally bound, should actually not be as controversial as it is, but we are talking about changing systems of powers that is always controversial. We can talk about adding term limits for future justices. We can talk about implementing ethics standards and transparency and accountability. We can talk about passing the John Lewis Voting Rights Advancement Act, the Freedom to Vote Act, the Disclose Act, the Supreme Court Ethics, Recusal, and Transparency Act, all bills that are already introduced in Congress, and they just need a little bit of support from the other side in order to get these things done. I mean, we can talk about all of these things, but I want to leave some room for my other panelists to give their opinions on this, because I know there's more that we can do.
Well, from National Action Network, Reverend Sharpton back in June said this in our support of expanding the court: Americans have lost faith in the justice system because biased decisions and clear-cut corruption have seeped into the highest court in the land. That's true. That's why National Action Network advocates with just more, changing a lot of the stuff on the court, not just about the expansion. Term limits ought to be on the table and all of that. There's a fundamental issue we have to deal with. For many Americans, the Supreme Court for a long time was perceived as holy or divine, that they were above the mess. And they have demonstrated clearly they never have been, but most folk didn't know that until very recently. Going back to Plessy versus Ferguson, when Plessy was done, they codified a racist, incredible standard that took years to get rid of, but most Americans even then thought, well, this is nuts, but they went with it. For us, we have to move, I believe, to doing more conspiracy work for the good, to combat conspiracy for evil, because dealing in a conspiracy-led society right now, people are concerned. We simply cannot always be so theoretical and high-sounding that we don't understand what's really going on, and people need to know. I think one of the challenges we have is to let folk know that the court is bought and paid for. And we're seeing what happens when the court is bought. That's easier to understand than some days we win on the law and some days we don't. As you said, Portia, so well, the court has a mandate, but it's not from us. And the mandate manifests itself every time they convene. In fact, one argument I got, they shouldn't meet every year. Maybe we shouldn't have them meet every 3 or 4 years, because every year they meet, they do more damage. So I believe, as National Action Network President Al Sharpton has said for us, that the bias and the unfairness of the court is known by us. We see it. But because folk believe the court is still holy, even that's 25%, that among those who believe in the court, we have to do something by making sure that people understand this is corruption. This, as much as corruption is in your local community, this is corruption. And the corruption is against people of color, against folk without resources or means, and against the same folk that they've always been against. So our effort has to be to tell the folk on the ground, voting in this election is not just about whether President Biden is older or not. Because if y'all really, Nikki Haley, if y'all really upset about Biden's age, I need to hear you talk about the age of Uncle Clarence Thomas on the court, because this really gets to the heart of the matter. So I agree we need to change structures. We need to talk about what a different court would look like, but we must do a better job of making sure folk understand the connection between the hell they live in and who sits on that court. And how do you change the court right now? By who wins in 2024. We cannot get so lost in our theoretical weeds that we don't keep it plain for folk. If you don't like the way the court is behaving, you have a chance to do something about this in November of 2024.
And just to also sort of add on to that, I think obviously, I mean, at Color of Change, the size of the Supreme Court has been changing a lot. It's fluctuated a lot over time. And so I think it's very possible to go and increase the number of justices there. But I think there also needs to be a cultural shift inside, with voters, especially on the Democratic Party, about, the importance of some of these judicial positions. Republicans have understood that. I mean, the creation of the Federalist Society a long time ago has been sort of creating a pipeline for some of these folks to get. I mean, you can't even, Republicans can't even, seriously win an election without naming several justices that they're going to appoint, And I think there is a clear difference with, some folks in the Democratic Party. And so I think I would certainly encourage folks on the other side of the Republicans to really think creatively about what, the structure that the Federalist Society has done and what can we do to sort of replicate that. Unfortunately, some of these justices are going to be in these seats for a very long time. There's not much we can do to get rid of these folks. I mean, these people are in their the judges that Donald Trump and Mitch McConnell, pushed through are quite young. I mean, it's a 30-year game that Republicans have been playing, and Democrats did not play that game. And so what can we do to increase size, knowing that we're not going to get rid of some of these people, but we also have to start playing the long game and really having a cultural change about how we are thinking about the importance of the courts, because these folks are, as everyone said, they're supposed to be the fair arbiters of the law and the Constitution, but they're clearly not. And we got to play the long game, and I think that is sort of the critical question of how we can accomplish that.
Cool. We have 1 or 2 more minutes. April, Lindsay, any last words on court reform or these issues we're talking about?
No, I think what everyone has said is what we need to all digest. All the reforms that have been suggested are things that we should be fighting for. And I'll just reiterate that, the court, had not the community, organized themselves during the civil rights movement, we probably wouldn't have gotten the Brown decision, the subsequent accommodations decisions. All of that happened because the mood of the nation had changed. The outcry of the people was very, very well known, not just at the voting boxes, but at protests and different things of that nature. We've got to understand the importance that we play, that we're not powerless, and these reforms that are suggested are possible if the people demand it. And so we need to join organizations, and even at the micro level, in your county governments, in your city governments, your local elections, change can start there and build its way up. We get very, very infatuated, as we should, with what's happening on the national level, because for many marginalized communities, that has been the place of protection and reprieve. But we have to understand that we've got to fight for every political representation at every single level. So a lot of the changes that we're asking for, voting rights strengthened, more constitutional rights, can also happen at the state and local levels. Fight there too, and allow it to bleed its way up to the national policy level. So that's just the only recommendation. We're not powerless. History shows us that we can win, and that when we work together, we do win. And that's just all I want to add to all the other genius that has been discussed today.
Brett, just for a moment, April said something so fantastic. Jesse Jackson mastered explaining our pain in slogans that people remember long after he'll be gone from the scene. Same thing Reverend Sharpton did with "Take Your Knee Off Our Neck." The folk on the ground needs for us to make it plain why this is a threat, but it's not the end. And mobilizing requires folk to have somebody name your pain. Let me tell you what this is about and why you have to have to not just react, but act. So when people know that marches and demonstrations do work, they do. They work for a long time. But also organizing enough to change the face of your folk in your legislature and the allies who come from that. So it's very important for us to not give up on what changed the game for us as the people and the nation, is that the work that was done by folk in the streets finally reached the suite and finally reached the legislative halls. How did that happen? Because the folk on the ground organized. I love April's quote about organized to change our future. Folk who are not organized will not get a chance to win, because we're going against organized evil, organized hate, organized racism. So we have to be organized on the other side. That sounds kind of esoteric and beyond what we can do. But the truth is, we got here because of organization. Every organization on the screen that I'm looking at got on the table because of organization. And we should not let that part of our playbook be played by other folk. We can't get away from having folk understand they're coming for you, but you don't have to let them have you. You can respond to organization. So let us not overlook the importance of organization at ground level. It sounds like some of the stuff that we've heard and folk believe just sloganeering, but it's not. It really does make change. I've seen it already. And what we're dealing with right now is stuff that seemed impossible, change. And let's not have folk give up because we don't tell them what time it is. We do make the conversations more complicated than they are. As the folks here on the block, it's about the money, dog. If you don't understand that, then you don't know what's going on. It's about the money.
I'm going to have to leave it there. April and Reverend Rivers, thank you so much for these inspiring words at the end of our talk. We wanted to just drop into the chat for everybody who's listening 2 quick calls to action. If you're looking for something you can literally do in the next 2 minutes to help the case for reform. Stand Up First, Stand Up America, Demand Justice, other organizations are gathering signatures onto a letter right now to Senators Schumer and Durbin, urging them to pass a code of ethics for the court and use their subpoena power to fully investigate Clarence Thomas, Samuel Alito, and their ethical breaches and subpoena their billionaire benefactors. I think Sam from Demand Justice can drop that letter if you'd like to sign it or circulate it into the chat. Second, we can also drop into the chat a tool which would allow anybody to email their member of Congress to support a Supreme Court Code of Ethics, expanding the court and term limiting the justices. So feel free to use those tools. If you want to mirror those tools, feel free to reach out to me or Sam over at Demand Justice. I just want to, I know we're over time. Thank you all so much for joining, for listening. I want to thank our incredible panelists. I feel inspired, angry, and I feel like I learned a lot. So thank you for sharing your time and your expertise with all of us, April, Michael, Lindsay, Reverend Rivers, Portia. Really, really appreciate it. Thank you all so much. And to everyone else, thank you. Have a wonderful weekend. Thank you.
Thank you very much.